All right, good morning and welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. When you hear your name, please say present or here. Rebecca Hunter. Rebecca Ann Hunter. Sanctions Court. Miranda Opright. Charles Paul. For the record, cause number CR 17381, the court has granted the waiver of community service for Mr. Paul. Ricky Sanchez.
Present.
LaJasmine Woods. Daryl Ingram. Daryl Wayne Ingram. Is this the one you added on?
I did, but it's my understanding of the state.
Okay, I'll recall it. I'm not aware.
He's in custody as well. That's the same one that I think he's.
If something was filed yesterday, I haven't had a chance to review it. Julian Bahina.
He's with Mr. Bingham.
Billy Otmo. Angelo Adams. Angelo Taekwon Adams. Matthew Graham. Matthew Wayne Graham. Keith Meredith.
Here.
Joshua Nowak. Evan Page. Brent Smith. Kenneth Taylor. CR 22195, I believe confirmed in the Gregg County Jail. Mr. Schmidt will recall that case. Humberto Vergara. Humberto Vergara. CR 2438, for the record, Cynthia Joyce Warrington, waiver of arraignment, filed, approved pretrial set May 28th. Preston Wilson. Preston Mitchell Wilson. Federal detainer still. We'll recall that case. Wayne Allen Wingo. Daytona Blue. Jesse Ryan St. John, waiver of arraignment, filed, pretrial set May 28th, CR 2436. Wesley Ball.
Here.
Jose Funes. Tim. All right, I'll recall those. We have interpreters for Mr. Funes, Mr. Manzanares. But do we have an interpreter lined up at 10? All right, do we have any attorneys that are ready? I'm ready, Your Honor. Be ready on Mr. White.
I just got one today, Mr. Ball.
Wesley J. Ball, CR 23. Can't. Somebody, I can't read the cause number, so I can't call the cause number. It's 230 or 239, 232. CR 23232. Mr. Ball set for pretrial.
Your Honor, at the previous pretrial, we had talked to the court about some scientific evidence that we were waiting on from DPS. Mr. Hernandez provided me with a copy, I believe yesterday, of the most recent report. Obviously, I haven't had a chance to go over that and go over it with my client. I'm going to need another pretrial. Previously, I've talked to the court a little bit. At the end of this month, I'm going to be moving offices. I'd ask for just a little bit more time on this than more.
What about May 28th?
I think that'll be okay, Your Honor.
All right, court sets Mr. Ball for pretrial May 28th. That'll be at 9 a.m.
Free to go, Your Honor.
Yes, free to go.
Your Honor, may I approach real quick?
Yes.
Your Honor, may I interrupt? I think you called Daryl Ingram.
He did, and Richard said something to him as well. He said he was gonna recall it.
Okay, that case was declined yesterday, Judge.
Okay. Good, Mr. White.
Your Honor, this second pre-trial, we don't have anything additional. And I was asking if I could approach the bench.
All right, cause number CR 23-201, State versus Daytona Wayne Blue. The court's going to reset docket call for Tuesday, May 28th at 9 a.m. Mr. Blue gets his notice. He's free to go. We have any other attorneys that are ready? Ricky Sanchez, CR 16145. Ms. Sanchez, I believe that you are currently on community supervision and the probation department has filed a motion to adjudicate your guilt and to revoke your community supervision. Have you had an opportunity to consider whether you're going to request a court-appointed attorney or if you're going to be hiring an attorney to represent you?
I'm going to be hiring an attorney. I've spoken with Mr. White.
Okay,
And that's correct, Your Honor. That would be tried to see.
okay. Do you want me to, well, I'll tell you what, Ms. Sanchez, what I'll do is I'll reset this case. I'm gonna reset it to Tuesday, April 30th. That's 2 weeks. All right, that should give you 2 weeks to discuss with Mr. White or whoever you're gonna hire. Is
Okay,
that enough time?
thank you, yes.
All right, and then and that's not gonna be a contested hearing if you are hired, Mr. White, 'cause that's just 2 weeks, but I'm gonna put it on the motion to revoke docket.
Let me jump ahead of them on one.
Well, he does have 42 cases set, so he's a gentleman. He's a
He
gentleman.
is.
All right,
He is.
Mr. Otmo, CR 22235.
Judge, Mr. Otmo, we're getting the paperwork done on that. That's going to be a plea. And then we'll have another one downstairs, I think today. So we're getting that done and I have one other one, Julian Bahena.
Are you ready, Mr. Bahina?
We're going to ask Judge that we reset it to April
Is Mr.
30th.
Bahina, is he here?
Yeah,
Yeah, come on up so he can be a part of all this. For the record, this is cause number CR 18456, State versus Julian Martin Bahena. Go ahead, Mr. Bahina.
Thank you, Judge. We're asking that it be reset to April 30th at 1:30 PM on the contested docket. In all candor to the court, it's going to get resolved. But we just like to resolve it on that date if I could. We're still working out a few details, but it gives the defendant time to get a few things in order with his job that he has to get in order. The DA's office has been great to work with on the case. There's 16 allegations. And he understands that he's going to go probably into custody that day, but we're going to plead true if we just have that little bit more time. He's got a young child and a job, and he just wants time to get that coordinated.
Any objection from the state?
No, Your Honor, and we are asking for an afternoon setting that day. If we do get it worked out, it will be for time, so it would be at the jail.
All right, court will set Mr. Bahena then for a hearing on this motion to adjudicate on Tuesday, April 30th at 1:30.
Thank you, Judge. That's all I have, Judge, with Mr. Bahana's case, but he'd be excused.
Yes, you're excused.
Okay. I think we can hand change that.
Mr. Schmidt, are you ready now?
Start with Josh with no way.
Mr. Nowak? It's cause number CR 2365. Retrial. Go ahead, Mr. Schmidt.
Judge, as of today's date, we have not filed any contested pretrial motions. I presume that there's a likelihood we may have to do that in the future due to some discovery that hasn't been analyzed. We'd ask permission to file, if necessary, late pretrial motions, but as of today, ask that we move on to docket call.
What's the holdup on discovery that you're waiting for?
Judge, there's a significant amount of digital evidence that was seized, and I believe it was transferred to a federal facility for evaluation. They're in no hurry. And I'd be surprised if we get that anytime soon, so I don't want to hold this up for that.
All right, then the court will set Mr. Nowak for docket call. The court will grant permission to the defendant to raise pretrial motions late based on the good cause stated by Mr. Schmidt. You want to do May 28th?
Yes, sir.
All right, court sets Mr. Nowak for May 28th for docket call.
I did the Brent Smith. Step stipulation.
Relief.
Free to go. And Mr. Nowak, can you make a payment today towards your delinquencies?
I actually made one last night. If you'd like to see the email receipt, I can actually show
No,
you.
just tell me what you paid.
I paid 75 last night.
All right, thank you, sir. We'll see you back on the 28th. Thanks, Mr. Shaw.
Keith Meredith.
Keith Meredith. This is cause number CR 23-164 for docket call.
Judge, I'd ask for a final docket call. Give us an opportunity, hopefully to work this out. Yes.
All right, court will set Mr. Meredith for a final docket call. Hearing no objections from the state, we'll set it for Tuesday, May 28th. Mr. Schmidt, I have a couple of pretrial issues I want to discuss with you. I have a note of pretrial release saying that he failed to report on March 24th, that he's only $180.
Yeah. I didn't know anything about it after the court date. I said, "What about that?" Judge, states he can make a payment of roughly $60 by tomorrow. As far as the non-report, he didn't understand that if we don't have a court date in a given month, he has to set up to meet with pretrial. He presumes he had to meet at court dates.
And you know, now that's not the case, Mr. Wilson.
Yes, sir. I understand.
If they call you and they say, get in here and take a drug test or get in here and report,
Yes, sir.
your conditions say that. Did you read your conditions that you signed?
Sir.
Did you read your conditions that you signed?
Yes, sir.
All right, so nowhere in there does it say you only report on court dates. You understand that? He's your pretrial release officer. If he says,
Yes.
get in here, you get in there.
Yes, sir.
Understand? So I want you to go over and meet with Mr. West before you leave today and make that payment by tomorrow.
Okay.
All right, you want to follow Mr. West?
Goodbye.
Anybody, yeah. Who's next, Mr. Schmidt?
Wayne Wingo.
Mr. Wingo? This is cause number CR 2467. We're set for I believe a pretrial release issue in arraignment. Is that correct? Let's go ahead and talk about arraignment. Go ahead, Mr. Schmidt.
Yes, sir. As far as arraignment's concerned, received a copy of the indictment, his name spelled correctly, understands the charges against him. We'd waive formal reading, enter plea not guilty, ask for docket call setting. Pretrial setting.
All right, court will find that Mr. Wingo has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record, and the court will set Mr. Wingo for pretrial hearing on Tuesday, May 28th. It'll be at 9 a.m. I want you to have a seat. I'm going to recall your case in a moment. Looks like we're probably going to need to have some testimony on your compliance or non-compliance with pretrial release. So go ahead and have a seat. You're not free to leave. I'll call you back up in a moment.
Evan Page.
Cause number CR 1963, State versus Evan Andrew Page for pretrial. Go ahead, Mr. Chair.
We don't have any contested pretrial issues at the time, and that's been set for docket call.
All right, the court sets Mr. Page for docket call on May 28th, 9 a.m. Mr. Page, have you signed your conditions of pretrial release yet? Did you meet with Mr. West, the pretrial release officer this morning? Have you done that yet?
This morning, yes.
Okay, so you've already signed and got copies of your paperwork? Okay, so after you get your notice, and Mr. Schmidt's done with you, come over here and meet with Mr. West and get your paperwork signed up, okay? Ms. Woods? Oh, Mr. Woods? Is your attorney Scotty Allen? Is that a male or female? Male, is he here? Okay, have you talked to him today? Do you know if presuming he knows to be here? All right, why don't you go ahead and step out in the hallway and try to call him again and see if you get a hold of someone at his office or whatever, and see if we can get a estimated time arrival. Thanks, sir. Not yet. Do you have, who is this?
This is Mr. Jose Funes.
All right, good morning, Ms. Beal. How are you? Doing fine. Thank you for being here. I'm going to go ahead and identify you and swear you for the record. If you will, go ahead, state your name and your license number for the record. All right, Ms. Beal, go raise your right hand as I administer the oath. Ma'am, do you solemnly swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? All right, thank you. All right, and for the record, this is cause number CR 23-126, State of Texas versus Jose Martin Funes. Mr. Schmidt, I believe that we are set for docket call today. Go ahead.
We are, Judge. We'd ask that the matter be set for a plea on May 28th.
All right, court sets Mr. Funes for plea before the court on May 28th at 10 a.m. Luis Miguel Funes Rivera. Tilt our laptop so that Ms. Bill can see. This Mr. Funes Rivera is a little shorter. Yeah, that's better. She can see him. All right, go ahead, Mr. Schmidt. This is cause number CR 23-127.
That's correct, Judge. We'd ask the matter be set for plea May 28th, 10 a.m.
Court sets Mr. Funes Rivera for plea before the court on May 28th at 10 a.m. Lazo Daniel Manzanares. For the record, cause number CR 23-130.
Ready?
Ms. Beal, can you speak with Mr. Manzanares? Does he have a good connection? Okay, great. Go ahead, Mr. Schmidt.
Judge, we'd ask to set this for plea on May 28th, 2024 at 10 a.m.
All right, court sets Mr. Manzanares to enter his plea before the court May 28th at 10 a.m. All right, court calls cause number CR 23-131, State versus Lesky Rodriguez Miranda.
Same announcement, Judge. We'd set Mr. Rodriguez Miranda for a plea on May 28th.
Is your client able to hear Ms. Beal? Let's try again. Ms.
Which one?
No. You cannot.
Ms. Beal, he's saying he's not able to hear you.
Down to the deck.
That should work. It has audio now. Try it now, Ms. Beal.
Well, nobody?
No. All right, just take them off, Any,
Well, okay.
thank you, Ms. Bill, sorry, I'm not sure what happened right there.
Right there.
Did I announce that for the record, Mrs. Grisham? That Mr. Rodriguez Miranda is set for 10 a.m. on May 20th.
Oh, no. Mr. Schmidt.
Yeah, I'm not sure I put that on the record. I believe they understand, and I believe Ms. Bill, that's what you told him, correct? Bring him back in.
Bring him back.
Bring him back in. We're gonna do it, we'll do it right.
Did not hear anything from the interpreter.
Come on up, Mr. Rodriguez. Okay. All right, Ms. Bill, if you'll just, and we'll do this simultaneous. Ms. Bill, if you'll just let Mr. Rodriguez know that he is set for plea before the court on May 28th at 10 a.m. All right, thank you. All right, you're excused. That's it. All right, thank you, Ms. Bill. I believe that's all that we have for you today. I know you're sad. I know you're saddened by that. Thank you, Ms. Bill. Appreciate it. Have a great day. Hey, Ms. Curry, the state never filed an information on Daryl Weenie that you made the announcement on earlier. Is that correct? The state, you made an announcement on Daryl Wayne Ingram earlier that the state had rejected that. So the state did not file an information. That's what Ms. Abraham was requested to do, was to set it for plea by information. I'm just trying to make sure that we don't need a dismissal.
Yes, Your Honor, that's correct. When we had negotiated a plea agreement, in reviewing the case, getting the paperwork ready, I discovered that there was a significant element missing, and we rejected the case instead.
Okay, all right, I'm just gonna mark it.
And we sent that to the jail yesterday, so he should have gotten out last night, but I haven't checked this morning.
Okay, good. I'll have this Abraham check. That was one thing that Mr. Schmidt asked about earlier this morning. Yeah, let's go ahead. We can go ahead and read this one. Yeah, I just have to. State of Texas versus Joe Otmo. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You lower your hand. Mr. Otmo, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental health condition?
No, sir.
In this case, you're represented by your attorney, Mr. Matt Bingham. Are you pleased with Mr. Bingham and his representation?
Yes, sir, I am.
I feel like you've had enough time to talk with him about both of your cases and that you've had all of your legal questions answered.
Yes, sir.
Is there anything, Mr. Otmo, about the paperwork and part of your plea agreement today that you do not understand? Is there anything in this paperwork that you do not understand?
No, sir.
Mr. Bingham, do you believe Mr. Otmo to be competent?
He is competent.
And you've explained to him his rights as they pertain to each case?
I have.
And do you believe that he is entering into these plea agreements intentionally, knowingly, and voluntarily?
I do.
All right, Mr. Otmo, in cause number CR 22235, you are charged by information with a Class A misdemeanor offense of terroristic threat. Class A misdemeanor does carry a range of punishment of not more than 365 days confinement in the county jail and a fine not to exceed $4,000. I see the plea agreement in this case is that you would plead guilty to terroristic threat. The state's recommending that you be convicted of that offense based on the evidence, that your punishment be assessed at 60 days confinement in the county jail, with you receiving credit for 5 days of time already served, a fine of $500, and this plea to run concurrent with your next case we're going to be discussing, 2024-59, and that you would be going into custody today. In addition, you would have court costs of $270, reimbursement fees of $15. Is that your understanding of the plea agreement in that case?
Yes, sir.
All right, with regards to 2024-59, you are charged by information with the Class A misdemeanor offense of assault causes bodily injury, carries the same range of punishment, not to exceed 365 days in the county jail, or a fine to exceed $4,000. The plea agreement in this case appears to be upon your plea of guilty. The state's recommending that you be convicted of that offense, that your punishment be assessed at 60 days confinement in the county jail, with you receiving credit for 3 days of time already served towards that sentence, a $500 fine, $270 court cost, $15 in reimbursement fees, with you going into custody today to serve the remainder of your sentence. Is that your understanding of the plea agreement in that case as well?
Yes, sir.
All right. Mr. Otmo, then I would ask you, how do you plead to terroristic threat and assault causes bodily injury?
Guilty.
And you're telling me that you're guilty of committing each one of those offenses because in fact you are guilty of committing those crimes?
Yes, sir.
Mr. Otmo, has anybody threatened, forced, or pressured you to plead guilty to either crime?
No, sir.
All right, the court will accept the defendant's plea of guilt in each case respectively. Mr. Bingham, any objection to the stipulation of evidence?
No, we have no objection being marked and offered or offered.
All right, stipulation of evidence is admitted in each case. Court takes judicial notice of Mr. Otmo's judicial confession. Anything further from the state,
No, Your Honor.
from the defense?
Only I believe that want to make sure that the the assault case does not reflect a family violence finding. And that the state has also agreed as part of the plea agreement, in the assault case, to decline to prosecute the injury to a child case that he was also arrested for, as reflected in the paperwork.
That's correct, Judge.
Yeah, court sees no affirmative finding or allegation for assault family violence in the plea paper.
Thank you,
that
Judge.
judges. All right. The court's going to review the evidence. Right. Based on the court's review of the evidence, court finds that there is sufficient evidence to convict Mr. Otmo of each of these offenses. The court, the state will follow the plea agreement. Cause number CR 22235, the state convicts Billy Joe Otmo of terroristic threat, a Class A misdemeanor. The court assesses his sentence pursuant to the plea agreement at 60 days confinement in the county jail, with him receiving credit for 5 days towards that sentence for time already served. court fines him $500, $270 in court costs, $15 in reimbursement fees, and orders that this sentence run concurrent with cause number 2024-59. In 2024-59, the court hereby convicts the defendant based on the state's recommendation of assault causes bodily injury and assesses punishment pursuant to the plea agreement at 60 days confinement in the county jail with credit for 3 days of time already served. Court orders a fine of $500, court costs of $270, reimbursement fees of $15. Mr. Otmo, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of this sentence. I'm gonna have you come forward to be fingerprinted, after which you'll be taken into custody to serve your sentence. Yes, yeah, good to see you. All right, Mr. Schmidt, are we ready, Mr. Collier? Just about. Couple minutes. Jimmy, go ahead and bring him up for you.
You can do that, or we can do Mr. Smith, he's ready to go.
Mr. Smith, do I have paperwork? Mr. Smith?
I'm bringing him to.
Mr. Smith, come on up. All right, this is cause number CR 24-68, State of Texas versus Brent Lee Smith. Mr. Smith, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can lower your hand. Mr. Smith, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with his representation?
I am.
Is there anything about your plea agreement and the paperwork that you signed today that you do not understand?
No, sir.
Mr. Schmidt, do you believe Mr. Smith to be competent?
I do.
You've explained to him his rights as they pertain to this case?
Yes, sir, I have.
And do you believe that he's entering into this intentionally, knowingly, and voluntarily?
Yes, sir.
All right, I see, Mr. Smith, that you were originally indicted with sexual abuse of a child under 14, aggravated sexual assault, and injury to a child with criminal negligence. I see today that the plea agreement is that you plead guilty to an information, waiving your grand jury rights, to an attempted, is this attempted?
It's a state jail, injury to a child, criminal negligence.
Okay, so it's not attempted.
No, sir.
Okay, I'm sorry. I see that the offense for which the state's recommending that you be convicted is injury to a child with criminal negligence. Do you say criminal negligence?
Yes, sir.
It says with intentional bodily injury. Is that correct?
Probably not.
Why don't y'all come up here and let's look at the paperwork. All right, let's see here. All right, so we're gonna have to start over. So it looks like the recommendation to the court on this plea agreement is that Mr. Smith plead guilty to injury to a child with criminal negligence, a state jail felony, that the prosecution would proceed under section 1244A of the Texas Penal Code. And their recommendation is that the plea agreement still says attempted injury. Is it attempted or is it just?
It's not.
It's not.
Judge, you want to recall the case and I can go
I
back and
think we're close.
clean up all the paperwork.
Plead guilty to lesser included offense. So it's not a lesser included offense either, right? Because this is a new information.
That's correct.
Yeah, let's just go ahead. We'll recall this case. That way we'll clean it up a little bit because the jail may be confused by the time
Can't catch
I'm working over there.
it.
It's all right. That's why I was confused earlier. I knew I had read it somewhere.
Approach yet? It's just a question. It's not.
Our,
He bonded out. I don't believe that I've ever had any contact with Mr.
court is going to call his name in a docket. Yes, sir. Not some. Let's see, cause number CR 23-8, waivers was requested from Mitchell Wilson. We had him set for status today. He's still being held on a federal detainer.
What's the state's position? Same. So let me.
Reset, Judge.
My court will set Mr. Wilson for another status on his federal detainer. May 28th. All right, we are back on the record, cause number CR 2468, CR 2435, CR 21392. All right, Mr. Smith. It appears that the plea agreement in your case is that on this charge of injury to a child by criminal negligence, a state jail felony, that you would be pleading guilty to that today in exchange for the state's recommendation that you be convicted of that offense and that your punishment be assessed under section 1244A as a class A misdemeanor to 1 year confinement in the Van Zandt County Jail, with you receiving 365 days credit towards that sentence for time you've already served in jail. In addition, you would be responsible for court costs of $290 and reimbursement fees of $15. Is that your understanding of the plea agreement?
That is correct, sir.
All right, Mr. Smith, to the state jail felony charge of injury to a child with criminal negligence, how do you plead?
I do plead guilty.
And are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
And has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
The court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
Stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state? And Ms. Curry, I'm assuming that there's been victim compliance with regards to the proposed plea today. She and her family have been informed about the nature of the plea, the reduction of the charge, and they're supportive of it.
Yes, Your Honor, Mr. Hernandez met with them personally and on this, and very
All right, thank you. All right, court finds that victim is supportive of this plea. Anything further from the defense?
No, sir.
All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Mr. Smith. The court does follow the plea agreement. Court convicts Brent Lee Smith of the state jail felony offense of injury to a child by criminal negligence, assesses his punishment pursuant to the plea agreement at 1 year confinement in the Van Zandt County Jail pursuant to section 1244A of the Texas Penal Code. The court orders that Mr. Smith receive 365 days credit towards his sentence for time that he has already spent in jail on this cause. Counsel, your approach. Furthermore, Mr. Smith, the court orders you to pay $290 court costs and $15 in reimbursement fees. All right, Mr. Smith, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. I'm gonna have you come down here to be fingerprinted with Deputy Martinez, and then you will be released. For the record, the court is signing and granting the orders to dismiss on the motions to dismiss in CR 21392, CR 2435. Mr. Schmidt, Mr. Hernandez, if you'll approach. Do you swear that the truth, the whole truth, nothing but the truth, so help you God?
Yes.
The Collier, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental? In this case, you're represented by your. Are you pleased with Mr. Schmidt's representation?
Yes, sir.
Like you've had enough time to discuss your case with him, have all of the legal questions answered.
Yes, sir.
Is there anything about the paperwork that's your plea agreement that you've read over and signed today that you do not understand?
No, sir.
Mr. Schmidt, you believe Mr. Collier is competent?
I do, Judge.
You explain to him his rights as they pertain to this case.
Yes, sir.
You believe that during this plea agreement, the state potentially going.
I do.
All right, Mr. Collier, I did first. That does carry punishment of not less than 5 years or more than 99 years or life confinement in the Texas Department of Criminal Justice Institutional Division. I see that the plea agreement in your case is that you would plead guilty. I'm sorry, I believe you were originally charged with capital murder.
That's correct, Judge.
And the plea agreement today is that you would plead guilty to the lesser offense of murder. And that the state's recommending that upon your conviction and review of the evidence, that your punishment be assessed at 30 years confinement in the Texas Department of Criminal Justice Institutional Division. And the state is recommending the court to dismiss the other case, which is an aggravated assault with a deadly weapon. There's also a part of this agreement that the weapon used in this offense would be forfeited. And the state is agreeing to also reject an unfiled case of aggravated kidnapping with a deadly weapon. Upon accepting this plea agreement, the court would order that you would receive 804 days credit time towards your sentence for the time that you've already spent in jail on this cause. In addition, there's no fine recommended, no restitution, court cost of $290 and reimbursement fees of $20. Mr. Collier, is that your understanding of the plea agreement?
Yes, sir.
All right, then understanding the range of punishment in the plea agreement, Mr. Collier, how do you plead to the first-degree felony offense of murder?
Plead guilty.
Are you pleading guilty to that crime because in fact you are guilty of committing that crime?
I committed that murder, sir.
And has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence being admitted in evidence?
No.
All right, the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state? I don't think so, Your Honor. Thank you. All right. Anything further from the defense?
Judge, Mr. Collier had prepared a written statement that he would like to present to the court. We would ask that he be allowed to do that.
All right, court finds that the only individuals entitled to give a statement under the law is the victim in the offense or close relatives of the victims in a homicide. And so at this time, the court is going to find that Mr. Collier does not have a right to present a statement. So the court's going to deny that request.
Judge, if I may, it would be all right if I could present that written statement to the DA's office. Perhaps they can provide that to the victims outside of the court.
Yeah, court will not prohibit the defense from giving that statement to the state for communication to the victim's family if they so choose.
Thank you, sir.
All right, court's going to review the evidence. All right, the court has reviewed the evidence, does find that the stipulation of evidence contains sufficient facts to allow for the conviction of the defendant. The court will follow the plea agreement reached between the state and the defense today. The court convicts Ryan Keith Collier of the first-degree felony offense of murder. The court assesses his punishment pursuant to the plea agreement and on the recommendation of the state. at 30 years confinement in the Texas Department of Criminal Justice Institutional Division. The court takes into consideration and dismisses cause number CR 22127. State also finds that the court finds that the state is rejecting unfiled aggravated kidnapping with a deadly weapon, cause number DA 2022334. Court finds that there was a weapon used in this offense, makes an affirmative finding that it is a deadly weapon, a firearm, and the court also forfeits that weapon as part of the plea agreement in this case. Court orders Mr. Collier to pay court costs of $290 and reimbursement fees of $20. In addition, the court awards Ryan Keith Collier 804 days credit towards his sentence for the time that he's already spent in jail on this cause. Is there anything further from the state?
Your Honor, in terms of allocution, there are some family members present that might miss that.
All right, Mr. Collier, anything further from the defense?
No, sir.
All right, Mr. Collier, you're hereby remanded to the custody of the sheriff so he carry out the terms and conditions of the sentence. I'm gonna have you, actually just stay there. We're gonna bring the fingerprint to you. We're gonna fingerprint you. And after which then we'll receive the victim allocution. All right, Mr. Hernandez, at this time, the court will allow for victim allocution for those who wish to allocute. I'm going to direct the court reporter not to transcribe these proceedings.
Thank you, Your Honor.
What's your name? And we may proceed.
I know you don't care about hearing how much that Leslie was loved and how much we miss her and of the special memories we could have had with her. The fact is, you took the life of Leslie, who was a daughter, a sister, a stepsister, a mother, a grandmother, an aunt, and a friend to many. We have to live with the facts, but you have to live with the image of you shooting my daughter 3 times with a shotgun. I hope that that image you see every day for the rest of your life.
Leslie was my sister. I come to you today to let you know that you have put a hole in my heart and several people's hearts. It's the only one that's going to pass judgment here is God Almighty, and you will answer for what you've done. There's nothing that's going to take her place. You did not have the power to take her life. but you did it anyway. God is the only one that decides that. And you decided to play God. I hope that you never get to sleep at night, that you don't see her face when you go to sleep at night. And the wrath, I decree and declare right now, the wrath of God is going to come down on you like a mighty force. And I know this because I believe, and all I have to do is believe.
All right, Mr. Collier can be taken into custody and transported back to the Justice Center. Thank you all for being. Mr. Wingo. Going to have a seat there by Mr. Schmidt. I called Mr. Wingo. We had him earlier. I had about his pretrial release conditions, and the pretrial release officer, Mr. West, had requested that the court conduct a hearing regarding his compliance to the conditions of pretrial release. So we're back on the record. Cause number CR 2467. Just for the record, the court has already set Mr. Wingo for an additional pretrial hearing on May 28th. Mr. West, if you'll come forward, please. All right, Mr. West, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, go ahead and have a seat right here. All right, Mr. West, as the court's pretrial supervision officer, is it true that you requested that the court entertain your testimony today regarding Mr. Wingo and his compliance with his pretrial release conditions?
Yes, sir.
What would you inform the court?
That on January the 18th, a urine analysis was conducted on Mr. Wingo, came back positive for THC as well as alcohol.
Okay, did you discuss that with Mr. Wingo?
I did, and he admitted to it.
Okay, are there any other concerns that you have as this pretrial release officer?
No, sir.
I believe that you informed the court that he was also arrested for public intoxication on January 11th of 2024. Is that true?
Yes, sir, that is correct, that he was arrested for public intoxication.
I'm sorry, I can't.
Yeah, can you speak up so Mr. Schmidt? Go ahead, scoot your chair up.
Yes, he was arrested for public intoxication on January the 11th, 2024.
How did you receive that information?
He provided that information to me the day he come in on the 18th. He said he was subsequently arrested for that.
And when did Mr. Wingo get placed on your supervision caseload?
Around October 3rd, 2023.
Was Mr. Wingo aware of his pretrial release conditions?
Yes.
Had you discussed those with him?
The previous pretrial supervision officer. No, I did discuss those. Yes, sir.
All right, any other concerns with Mr. Wingo?
No, sir.
And you said that he was positive for THC and alcohol?
Yes, sir.
Questions from the state?
Yeah, just for clarification purposes.
Yes, I do. He's wearing a black shirt next to the defense attorney, Richardson.
All right, next. My record will reflect that this witness is identified, and in this case, Mr. Wingo in open court. Trent, your witness.
Yes, sir. Mr. West, you stated that on January 18th, Mr. Wingo was given a urinalysis
Yes, sir.
of this year, and the results were positive for alcohol on that test.
Alcohol and THC.
You stated that he admitted to alcohol. Did he admit to both or just the alcohol?
He admitted to both.
Did he admit to being around THC or did he admit to ingesting?
He did say he had been around.
Is it possible that he had admitted to the alcohol and not the THC, or was there some confusion there?
No, on the paperwork, when he signed it, he acknowledged that he was around it because we put both marijuana and alcohol.
Do you have a copy of that document? May I approach, Judge?
You may.
Did Mr. Wingo relay to you any reasons or any like events that were going on at that time? So maybe not a reason for that positive test, but an explanation perhaps.
For the alcohol or?
Yeah, at the timing in which he was tested.
He did say that he was arrested for alcohol. He didn't say exactly what day. So I then subsequently tested him in the UA. And then he came back positive for alcohol and marijuana.
But he did volunteer that information. Did he volunteer any information about having some sort of tragedy in his life that caused a relapse?
Not that I recall. I mean,
other than that, has he been reporting as ordered?
yes,
And he's been complying with the other conditions? He hasn't missed any court dates that you're aware of?
say it again.
Has he missed any appointments with you?
No.
Pass it.
Any further questions from the state?
Yes, Your Honor. So just for clarification's sake, it appears that the test that you asked him to take was on the 18th of January?
Yes.
And then there was some clarification that he was actually arrested for public intoxication on the 11th.
I wonder about the 11th.
So seven days at least. Fair to say in your training and experience dealing with folks and these tests that an alcohol test done 7 days after somebody has consumed alcohol is probably indicating more recent use of alcohol?
Yes.
It's not going to last 7 days in the system, is it? Now, in terms of the THC rule, does the language indicate clearly that it's not only is it the ingestion of the drug, but being around it?
I understand. Yes.
Would that be a violation of the pretrial condition?
Yes.
Pass the witness, Your Honor.
Mr. Schmidt,
No further questions, Joe.
Mr. West, anything further that you would report to the court regarding Mr. Wingo's compliance or non-compliance with his conditions of pretrial release?
No, sure.
All right, you may step in. Is there any argument by the state?
No, Your Honor, rest on the record. Thank you.
Any argument by the defense?
Judge, I'd asked to call Mr. Wingo for the limited purposes of his pretrial release
All right,
conditions.
Mr. Wingo, come forward. Sir, if you'll raise your right hand. You swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God. Just what you said, have seen. Court acknowledges that Mr. Wingo is being called for the limited purpose of the court's hearing today on conditions of pretrial release. Go ahead, Mr. Schmidt.
Mr. Wingo, you heard the testimony by your pretrial release officer, Mr. West, correct?
Yes, sir.
In addition to that, I showed you a document that was produced by him with your signature on it pertaining to a urinalysis test you took on January 18th. Is that correct?
Yes, sir.
Now, that did purport to have your signature. Was it your signature?
Yes, sir.
Now, when you signed that document, you had a verbal conversation with Mr. West. Is that correct?
Yes, sir.
In which you admitted to using alcohol.
Yes, sir.
Now, your signature on that document shows that you're admitting to ingesting or being positive for or using THC. You understand that's what that document shows, correct?
I can see that. Yes, sir.
Was that your understanding of what you were signing?
No, sir.
And when you were tested positive for THC at that time, did you explain to Mr. West why you believed you had tested positive for THC?
Yes, sir.
And what was the explanation that you provided to him?
I just buried my mother and was around a lot of people who were smoking.
So you had been at a wake and family members had been there and,
Yes, sir.
and a lot of people were using marijuana?
Yes, sir.
Now you understand that you're not supposed to be around any of that stuff,
Yes, sir.
but this is an unusual circumstance in that a family was there to bury your mother. Is that correct?
Yes, sir.
Now, did you visually see the results of that drug test?
Yes, sir.
So you understood that, were you surprised that it was positive?
Yes.
Now, whether you tested positive for that or just alcohol, you understand that consuming alcohol while on pretrial release is a violation of your conditions as well. You understand that? Now, without making any excuses for violating that condition, you understand that, or are you telling the court that that particular circumstance was a tragic family event, and ultimately, you relapse or regrettably drank at that point in time?
Yes, sir.
Since that date, and that was roughly 3 months ago, have you had any other issues that
No,
you
sir.
needed to report?
No, sir.
Going forward, are you able to comply with your pretrial release conditions so that your bond remains solid?
Yes, sir.
Now, you understand that life happens to everybody,
Yes, sir.
but not everybody is on court-ordered pretrial release conditions. So even though alcohol is legal, for you, it is forbidden. And regardless of whatever life events happening to you, you still cannot violate those conditions. Do you understand that?
Yes, sir.
And can you assure the court that going forward, if the judge were to allow you to remain on bond, that you won't have any additional violations?
No, sir, I won't.
I'll pass the witness.
Mr. Hernandez, any questions?
Just briefly, Your Honor, thank you. So Mr. Wingo, you actually admitted that you had been arrested for public intoxication, correct?
Yes, sir.
January 11th.
Yes, sir.
So it stands to reason that you had consumed substantial alcohol to bring you to the point to give an officer
The
reason.
day after my mother passed.
So she passed on the 10th, sir? Okay, I'm sorry to hear that. And so when were the services?
It was 2 days before I reported, so the 16th.
The 16th? Okay, so is it fair to say you consumed alcohol that day as well?
It was the day before the service.
That you consumed alcohol? Did you consume any alcohol on the day of the service, the 16th? What about the day after the service, the 17th? So what you've in essence done is admitted to the fact that you still had alcohol in your system 3 days after you had consumed it?
I guess.
And
Yeah.
what did you drink, sir?
I had a couple of
Object to
beers.
relevance.
Overall,
I'm sorry, sir?
I had a couple of beers.
So you had a couple of beers on the 15th, and then you were tested on the 18th and tested positive.
Yes.
I'll pass the witness, Your Honor.
sure.
No further questions.
Mr. Wingo, you can step down. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense, Mr. Schmidt?
Not as far as testimony,
Would you like any argument?
just briefly.
Go ahead.
Judge, I'll just ask the court, in circumstances, generally speaking, zero tolerance policy for violations of conditions of pretrial release. Mr. Wingo has been in compliance for all intents and purposes. Has reported no other issues to Mr. West, other than the, positive UA on the 18th. I would argue that there were extenuating circumstances that, although does not excuse the behavior, explains it. If this were an ongoing problem, I would ask, I would understand the court's reluctance to grant, relief to allow him to remain on bond. If necessary, Judge, I would ask, for the court perhaps to set him for additional compliance hearings on, and perhaps have him tested additionally to ensure that he remains in compliance. But we'd ask that the court not revoke his bond at this time.
Any response, rebuttal?
Your Honor, the only thing I think that I would point to is the fact that his credibility is certainly in question when he's asking the court to believe that 2 beers stayed in his system for 2, if not up to 3 days to give a result of positive for alcohol. That's highly unlikely, Your Honor. And I just, that really causes me pause, and I think there should be some concern by the court as well.
All right, thank you, Mr. Hicks. All right, then based on the evidence presented to the court today, the court finds that Mr. Wayne Wingo has violated the conditions of his pretrial release. Court finds that he has consumed alcohol. Court finds that he has been arrested for an offense regarding the use of alcohol. Court hereby finds that his bail is insufficient. Court is going to show him some mercy, understanding that, as Mr. Schmidt has said, it's not an excuse but an explanation. Court finds that Mr. Wayne Wingo's bail, currently at $40,000, is insufficient, and the court's going to issue new bail in the amount of $50,000 in order that Mr. Wingo be taken into custody at this time for his violations. So, Mr. Wingo, there's consequences for your actions. And this consequence is not as severe as it could be. You can ask your attorney, Mr. Schmidt. I usually double bail. You could be looking at $80,000 a bail instead of $50,000 a bail. So it might not seem like a break to you, but I can assure you that it is a break. So go ahead and take Mr. Wingo into custody at this time.
Richard, paperwork on Butler, is that yours? Butler, yours? Yeah, okay. I may have to give it to Mr. Grant. Thank you.
Let's see here. Yes.
Oh,
like I said,
okay. Okay.
Yes, if you'll call the name, Berto Vigata. Pronounce it just like that. Any response from Mr. Vergara? All right, court finds that Roberto Luis Aparicio Vergara was set for court today, failed to appear, was sent notice of today's setting. His name has been called loudly, distinctly 3 times in the courthouse with no response. Court hereby issues judgment nisi and alias capias. All right, court's going to stand in recess until 1:30, the afternoon docket.